for the most part, elections are up to a state. The Constitution says a state runs its elections. These states are put under federal guidance, the Voting Rights Act, because of past discrimination. So now the court is saying the test you had in place is outdated. It goes back to 1965. So much has changed. Our culture has changed. Our society has changed. Other discrimination laws have changed. Hopefully, these states have made substantial progress. So if you're going to do this, you have to rewrite the test, if you will. If you look at the politics of the moment, the president and his Justice Department made a very strong case to the Supreme Court that they wanted to keep this law in place. If you look through the states that are affected, most of them will have Republican governors, and this is a debate that's going to play out.
And not only in voter ID laws, but also in redistricting, such as the Texas redistricting plan. We're going to see how states handle this in terms of how they draw their congressional districts, and they could wind up in court.
And at least for now, Jake, the bottom line is that these southern states, largely southern states that had these special requirements that the federal government imposed in that 1965 Voting Rights Act, they are no longer going to have to deal with that, at least for the time being, unless Congress takes special action. And as I said, I don't anticipate that special action anytime soon.
That's right, Wolf. And what's interesting is, of course, the 1965 Voting Rights Act was renewed in 2006 for 25 years. It was an overwhelming vote by a very divided Congress. The vote was 390 to 33 in the House and 98 to 0 in the Senate. But I want to bring in Professor Jonathan Turley. What's interesting, though, is even though there was that overwhelming vote in favor of continuing the Voting Rights Act, Chief Justice John Roberts made no secret about his skepticism that it was still required.
Yeah, this is very much a long-term project for Chief Justice Roberts. You know, he stated years ago that he was highly critical of Section 5 particularly, although as Jeff mentioned, taking out Section 4 effectively takes Section 5 offline. But Roberts has been gunning for this for some time. What's different about this is the lack of deference to Congress. During the oral argument, both Roberts and Scalia chided Congress and basically said no member of Congress has the guts to vote against a bill like this because you don't want to be viewed as favoring racism or interfering with the rights of minorities. And so what you have here is a clear rejection of Congress and frankly a degree of contempt for Congress that came out of the oral argument. Now what's ironic about that is that Congress is now going to be in a much more difficult position because to change this law, you're going to have to talk about specific states. And before you just simply re-upped, you voted on the whole law. Now you're going to have to target individual states, and those delegations may find it very troubling to have their state put on that list and other states not.